We now return to Illinois Rising, presented by the Illinois Policy Institute, the radio show discussing the honest truth about Illinois policy and politics. Here's AM 560's Dan Proft.
Dan Proft back with Ted Dabrowski, Vice President of Policy at the Illinois Policy Institute. And Ted, this case of Harris v. Quinn, we've talked about it in this show before. This is a 2014 Supreme Court case. Pam Harris, this mother of a developmentally disabled child, her son, took a case all the way to the United States Supreme Court and actually won. I mean,
pretty amazing.
Almost, 5 years in the making. An incredible story. And essentially it was this idea that the home health care worker program that the state of Illinois administers provides for families who have a child with a developmental disability. And it provides a little stipend because, of course, the parent is in the best position to care for their child. And this is a stipend because that kind of setting is much better than some kind of institutional setting that the state would run. Okay. But that wasn't good enough for SEIU, the Service Employees Union. They wanted to actually intervene between, in most cases, parent and child and effectively unionize parents against their children for the purpose of this home health care program and really for the purposes, of course, of generating union fees for SEIU and their various political and policy ends. The Supreme Court struck this down, which was an important victory, particularly for parents who have a child with a developmental disability in the state of Illinois. But now there is a new case that's sort of piggybacking on that Supreme Court decision from last year. This is a lawsuit filed by the National Right to Work Legal Defense Foundation and the Illinois Policy Institute's Liberty Justice Center filed this week on behalf of 6 Illinois home care and daycare providers who seek to remove SEIU as their official representation. And we're now joined by Mark Mix. Mark Mix is the president of the National Right to Work Legal Defense Foundation. Mark, thanks so much for joining us. Appreciate it.
My pleasure to be on with you. Thanks for the opportunity.
So can you distinguish between the Harris v. Quinn case that the Supreme Court opined on, and so they have handed down a decision there. So if they handed down a decision and Pam Harris and similarly situated families won, so they're not forced to pay union dues to the Service Employees Union, what is the need for this lawsuit filed this week on behalf of home care and daycare providers?
Well, this is an extension, a logical extension of exposing the whole regime of forced unionism in America as it got planted back in the 1930s in our private sector labor law, and from 1915 forward it got planted in the government sector labor law. And the bottom line is that union officials have been granted an amazing power of what they call exclusive representation, which is more correctly called monopoly representation. And so this case in Illinois is an extension of the Harris case, where the court found that these home health care providers could not be forced to pay fees, or the clients could not be forced to pay fees in order to participate in a government program to a private sector union. These unions are private organizations, and they were granted this tremendous privilege to first force everyone into this collective representational scheme, and then the second injustice is to force them to pay for being forced into this monopoly scheme. And so this new case, where we're working with the Liberty Justice Center, and is to go after that original sin of forcing people into an organization they do not want to be involved in, never voted for, never asked for, and frankly, in the case of Illinois, never heard of. So this case goes beyond the forced payment of fees to really a core First Amendment associational issue of a private organization being allowed to force you into their representation, forcing you to accept their speech.
Now, I think everybody would buy that argument that people shouldn't be forced to have somebody represent them. What is it that the people are upset about when you talk about representation? Is it a lack of alignment with what the unions offer? Is it just that I have to pay my money there? What really bothers the people who are forced to pay this fee?
Well, I think many people have many different views about how they deal with forced unionism. I mean, there are lots of different reasons. They could be economic, they could be philosophical, they could be religious. But that's not for us to determine. What we're asking the federal court to look at is this primary violation of what is a First Amendment right. And it really exposes itself in a major way when you talk about government. The idea of unionization back in the 1930s in the private sector was this notion of, this industrial peace, this labor peace argument that somehow our country couldn't exist and couldn't continue if we didn't have this individual arbitrator in there, this labor union that would help protect labor peace. The idea that either do what we say or things will get bad for you. Well, they've applied that same model in the public sector, and so if we're to follow that logical conclusion, the worst employer in America today, the worst, most abusive employer in America today is guess who? Government, because they have the highest union density. That's not the case. Government unions do political work. Everything they do is political. The courts adjudicated that, saying, when they speak, they're speaking to government. They're redressing and petitioning their government. And the First Amendment protects our right not to be spoken for, if you will. We shouldn't have to give up that right. And so that's what's here. It's not for us to decide why someone doesn't want to be in it. It may be the payment of dues. It may be a host of other reasons. Our position is to protect the First Amendment rights, associational rights of citizens across the country.
We're talking to Mark Mix. He's the president of the National Right to Work Legal Defense Foundation. And Mark, it's an interesting point you make that kind of this is a predicate question. So you just explained it from the perspective of the daycare provider. Also, from the perspective of the union, because the arguments that are made by public sector unions often in cases such as this or policy discussions such as this, well, we're conferring a certain benefit to those that we're representing. And your point, is, if I've got it right, is to say, well, wait a second, I don't want your benefit. So even if I accept the premise you're conferring a benefit, I'm not interested in it. I don't want to pay for it, and you can't force me to take it.
Yeah, that's right. And so you have to assume that there is a singular definition of benefit in order to comply with that type of thought process. Unions say that everything we do is beneficial to you. Well, is a seniority system based on me being here one more day than you, Dan, so that I get a promotion whether you're a better worker and I'm not, but I get the promotion because I've been here one more day? Is the contract negotiation term that says the person that's been here one day longer is the person that stays during a layoff? Because those benefits, quote unquote, and I'm using my hand apostrophes here or whatever I'm supposed to, hand quotation marks. That idea of benefit, you have to understand what the unions are saying there is saying that everything we do is beneficial. And they even say, forcing you to pay fees to us that we use for purposes that you may not agree with is, quote, beneficial to you. That's just not the case. And it's particularly lightened up here when you talk about petitioning government. Jacob, who works with the Liberty Justice Center out there with IPI, said it best. He said, and I'm quoting from their release, said, under the First Amendment, individuals get to decide for themselves what they will say to the government and who will speak on their behalf. That condenses this thing down to the very essence of this case.
So, Mark, what you're saying is that I, as an employee or I, as a person, should be able to negotiate my own agreement with my employer or my government or whoever it is, rather than being forced to accept the exclusive representation, right? Where the unions will say, well, I can get you better raises or I can get you better terms. And I guess the point is that I, as an individual, maybe want different terms that don't match up with what the union's forcing me to take.
Yeah, that's right. And if the union can do that, if they really can do that and represent your interest, then you will join voluntarily. This is kind of the whole, when you boil out all of the discussions about compulsory unions in America, first you have the problem of compulsion. That's the first sin. And what unions are saying here is that, no matter what we do, we deserve the privilege of forcing everyone to accept us as their voice. And that really is a violation of what unions were started out to be in the first place. And, it was Samuel Gompers, the founder of the AFL, the father of unionism in America, who said, the workers of America adhere to voluntary institutions. Anything else is a menace to their rights. And what he meant was, when union officials rely on government power to compel people to participate with them, whether it be financially or through representational or through their voices, they are going to inherently destroy what brought together through voluntarism is much, much stronger. And so governments now, particularly in Illinois and the SEIU in this case, they've relied on executive orders from Rod Blagojevich, statutory authorizations by the Illinois legislature, and further, an executive order by then Governor Quinn to control this whole unit of home health care providers and daycare providers. And what we need to do there in this lawsuit is expand this precedent that was established in the Harris case that came out of Illinois, obviously, and say that, not only is the payment of dues a violation of the First Amendment rights, but this forced representation, this forced speech is a violation as well.
And Mark, the clients you're representing, the home care and daycare providers, were they victorious? How would this impact their the businesses they run?
Well, first of all, it would give them control of their voice back. That's the most important thing. It would break that monopoly power that the SEIU union holds over these people, and it would allow them to choose whether or not, if they believe the SEIU was going to be a voice in the marketplace for them, in this case in government, then they can join voluntarily. They can pay fees, they can participate, they can do whatever they want. If, however, they don't feel like this is the best voice or they disagree with them, then they can speak for themselves. I mean, the whole idea of petitioning government, the idea of redress of government, is that no private organization, no individual should be granted any privilege above ordinary citizens to redress their government. And that's the issue here, the idea of petitioning government. Can you force someone to accept someone to speak for them to government? And so they can join if they want. They can participate in SEIU activities. And frankly, if the SEIU were really thinking from a business model standpoint, they would go out and provide the best customer service, the best voice, the best service they could. And you know what? People would come and say, okay, I want you to speak for me. And that would be the ideal situation. And that's what unions have to do, no matter whether it be the government sector or the private sector. If they start representing the interests of workers, as opposed to the interest of the political class that they have to be relying on for their power, because they are now wards of the state under statutory law, under executive orders, under federal law, they're more interested in what happens politically than what happens on the shop floor. And what we're trying to do is rebalance that and say, hey, you know what? Go provide services and people will join.
Mark Mix, president of the National Right to Work Legal Defense Foundation. Mark, thanks so much for joining us. Appreciate it.
My pleasure.
Thanks, Mark.
Thank you.